In the last year, DRW has secured a number of great outcomes for our constituents using a multimodal advocacy approach. We help build coalitions, we work collaboratively with stakeholders, we work collaboratively with state agencies. Sometimes we file lawsuits, but we also do investigations and can sit down with people and develop creative solutions. And we did all of those things in the last year.
There's a concerted effort to go out into communities, into facilities, and even within government to say, hey, what do you think the protection and advocacy system for Washington State should be focusing on?
Allies in Advocacy is a cross-age, cross-disability advocacy organization. It's made up of people with disabilities. It's a very skilled self-advocacy group. We developed the Proclamation for the Dignity and Rights of Human Beings, and the document was entered into congressional record. And Disability Rights Washington's role in the Allies group is really just one of facilitation and support.
In June of 2014, Disability Rights Washington, along with OSPI, met with the Washington State School Directors Association, WSSDA, and we talked about, critical parts of any policy that we'd want to see in place. And as a result, WSSDA created Sample Policy 2337. What's really amazing is the focus on promoting education around disability history and awareness to make sure that students learn that they should focus on the whole person and not just on the individual's disability.
DRW joined in a lawsuit that was requiring regents to cover neurodevelopmental therapies to the same extent that it covers other treatments and surgical procedures. The lawsuit was requiring that regents stop using limitations and caps that were preventing people from accessing these therapies that they needed. So in 2014, the court recognized that DRW has authority to stand in a lawsuit to advocate on behalf of its constituents with developmental disabilities and mental health conditions. And later in 2014, the parties were able to reach an agreement, and under that agreement, as promised, Regents has started covering these therapies without limitations.
In 2014, the work we'd been doing at Lakeland Village was recognized by the Centers of Medicare and Medicaid Services. They found over 40,000 legal violations resulting from the inadequate services that DRW had uncovered.
So in 2014, DRW started a new project, the Amplifying Voices of Inmates with Disabilities project. It focuses specifically on working with prisoners with disabilities in our state prisons.
We've had a really good collaborative relationship in working with Department of Corrections to help people with disabilities in prison.
And through that partnership, we were able to accomplish the eliminating the self-harm infractions for inmates with behavioral disorders and mental illness. Inmates were being infracted for behaviors related to their disability. So we were able to eliminate those infractions coming from self-harm behavior.
After the TR lawsuit settled at the end of 2013 and was approved by the court, we have been meeting regularly with the state to plan the implementation of the settlement agreement.
Over a period of time, every youth in the state who might need these services and be eligible for Medicaid can access the intensive in-home services that the TR settlement is designed to deliver.
Because of the shortage in community mental health beds, people were warehoused in local hospital emergency rooms because they had been deemed a danger to themselves or others and needed psychiatric treatment. Warehousing individuals that need treatment but not giving them treatment violates their civil rights and liberty interests. And Department of Assigned Counsel reached out to us, along with the ACLU of Washington and NAMI of Washington, and did a joint friend of the court brief. An outcome of that is the governor and the head of DSHS requested emergency funding to create more evaluation and treatment beds where these individuals could go and get the treatment they have been court ordered to receive. And so that was a really good outcome, again, working with lots of partners in Washington State.
We compiled a report entitled Hours That Count.
The main goal of the report was to try to bring more integration to employment supports for people with developmental disabilities in Washington.
We were finding enclaves of workers who never had opportunities to interact with other coworkers who didn't have disabilities, or minimal opportunities to interact with coworkers without disabilities, and minimal or no opportunities to interact with the public or customers at large.
In 2014, Disability Rights Washington began looking at the issue of the Washington State Bar Association's application to become a lawyer in Washington State. We realized there were a couple of questions on there that singled out applicants who had sought mental health treatment, and we had a lot of concerns that, one, they were singling out applicants who had the insight to get treatment, and second, they were asking them questions about their treatment, including treatment records. We got a group of stakeholders together: law professors, law schools, firms, organizations.
We captured the voices of these people and produced a video called Questions of Discrimination. The video helps send the message to the bar that whether or not a person seeks mental health treatment shouldn't determine whether they're fit to practice law. And the final step will be to get approval from the Washington State Supreme Court.
As you can see from that wide range of subject areas, we're going to have to use a wide range of advocacy modalities to tackle those problems. And really the only thing that holds us back from doing even more is limited resources. The more support we get from the community, the more we're able to turn around and support the community in being as inclusive and supportive an environment for people with disabilities as it possibly can.